court's pretrial publicity order is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that that term just be limited to the prosecution team because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor.
That's him right there. Looks like he was yawning.
So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution team because if that term stretches beyond just the prosecution team, then the order as written, we don't believe is a valid and lawful order.
Yeah, there's 3,000 people there that day.
It would result in a prior restraint on certain speech. And at the very least would have a chilling effect on that speech. If the prosecution agrees that we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order and to make sure that they do not make a statement that the prosecutors themselves would not be able to make, a public statement. But if the order extends beyond that, then we have concerns because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not itself justify a prior restraint. As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity, that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures, and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with a criminal case. You have attorneys, that category of trial participants, certainly the court has the highest degree of ability to be able to restrain the speech of attorneys, and in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights, in talking about how this case has affected them. And of course, can't say that one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation.
Because they don't even know who they are, all the other
with that
witnesses.
order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you,
Okay, thank
Mr.
you.
Ballard.
All right, this is about a protective order, about what
Mr. Novak.
parties can discuss outside of the courts. This is the defense attorney for Tyler Robinson, the Charlie Kirk alleged assassin.
I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public, and it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at the conduct of and the court's expectations for counsel. So even if, under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may, in the future, be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this order is directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad, it's not vague, doesn't put the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are under subpoena at the last second. Because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers, we refer to it as a
on a rolling basis, as you know.
Potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants, and we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for the prosecution, and the court has expanded that to include the defense, and we don't have a problem with that. I also think that the standard that the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order. The best standard is actually the one that we believe the court should look to, which is the standard set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this constitutional question is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it, it's Tijerina, 412 Fed 2nd 661, 10th Circuit 1969, where the court says that the constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6, and we think it's the appropriate standard which should be applied here. That's part of, as we've told the court before, a motion that we will bring, because we actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, and it doesn't create a lack of clarity for the state, we would like it to be a little bit broader in other areas, especially concerning the standard to be applied and the definition of what is the prosecution team, but that's not germane to here. So we think that While we understand the state's concern, we think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench what it meant by a witness, and I think that's pretty close to what we described in our papers as a potential lay witness. So I feel like if I say anything more, I'm going to be reiterating again what's already in our papers.
Good call.
If I've muddled it, I'm sure the court will tell me and I'll clarify it. I hope I haven't.
Thank you, Mr. Novak.
Okay, thank you, Your Honor.
All right, and we'll turn to the last matter. Anything further, counsel?
All right, cameras have been approved in the courtroom, which is why we are watching it now. They moved the camera earlier
Yes,
this
thank you, Your
afternoon.
Honor. I do want to point out that the court's order, as it's written, does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members, or does it extend beyond that? And limitations on speech are a prior restraint. The court's order says that, if you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and then requires the parties to inform lawyers, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read, about the prohibitions contained in this order. So the order is prohibiting speech. And because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do.
Thank you, Mr. Ballard.
Thank you.
All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify.
So the
And
media
I'll hear
can,
from the parties on that.
I believe this is the media issue, so this is probably a media representative who's trying to intervene.
Thank you, Your Honor. David Ryman, representing the news media. Mr. Judd and I represent different groups of clients, so I'm going to invite him, if I miss anything, to weigh in after I'm done. But my intent, the issues are basically the same, so my intent is to address them for all of the interveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing. That is settled law in Utah. And the last filing at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago.
I got those queued
basically
up.
gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the civil procedure rules in a criminal case, they said we don't need to do that. The woman in that case just needed limited party status. And so in a way, we're not really, the state really hasn't disagreed with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers we've cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out, but it kind of sounds like just this sort of ad hoc, show up anytime you happen to see something on the public docket that might affect the public's rights, and that's just not the orderly way that this typically happens. The other thing, as I've mentioned in our papers, that it does is it allows for the media to be able to take an appeal of a closure issue without having to rely on the court's extraordinary writ jurisdiction.
Right, they've already had
And,
closed hearings in this
that was
case.
what they had to do in either Kearns Tribune or Bullock, where the media was not granted party status. And it is the situation that happened in FL, where they had to review her claim regarding records under extraordinary writ jurisdiction rather than invoking their appellate jurisdiction because she was improperly denied limited party status. So all of that authority supports the process that we are requesting in this case. We think it's the most orderly way to do it, and I'll end just by saying, there's been some discussion, and especially from Mr. Robinson's attorneys, about what rule it is that you need to do this under, whether Rule 24 applies. They seem to suggest that it doesn't. I will just point the court to two different rules that give you the authority to do what we're requesting, aside from Rule 24. Rule 24 is in the civil procedure rules, but Rule 81, and particularly subsection F of that rule, says that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, and that's in the criminal procedure rules, and that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, or it's not civil procedure, but rather just procedural matters. And so that is essentially what happened in the FL case, which is that, whether you do it under Rule 24, whether you do it as a judicially created, remedy, it doesn't matter. It's the same, it gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing, we didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why we're here today, a lot of time this just happens by stipulation, because these, the state and Mr. Robinson's lawyers, they may not want to fight over a particular issue. And so it really is a situation where no one really represents that interest. And the purpose of this whole process is to give the court the benefit of the briefing that we've submitted and the benefit of arguments to represent the public's right to attend these proceedings. So
we appreciate that.
Unless the court has any questions, that's all I have.
Thank you.
Thank you.
Nicely done. There was a prior
state. Mr. Beller.
There was a prior closed-door hearing on this, so the media moved to intervene, so they couldn't do any more closed
Your Honor,
hearings.
as the state briefed in briefing on a prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding.
Okay, do the prosecutors want the media
there's
in?
well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings and to court documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do just exactly what they've done in the closed session that we held earlier. So it doesn't make them a capital P party to the case, it makes them a limited purpose party, and they certainly have the right to be able to do that. Thank you.
Okay, nice. Yeah, prosecution. Yeah, let the media come in. Nice. So we got cameras approved in the courtroom. They had to move the camera so it wasn't right on top of Tyler Robinson. This is his defense attorney.
So I just want to clarify, the issue really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case.
Yeah, they have.
And I think another part of that is what that means. And really, that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's what we learned from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. there are very few instances where we're dealing with this in a criminal case on appeal. So we're a little bit in the dark, and we're asking this court to kind of wade through and make a decision that potentially hasn't been made before. But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.04, and their role is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this court to make the procedure very crystal clear. We want time frames. We want orders saying this is when you need to respond, so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time, and we're not unreasonable folks. If they reach out to us, we will grant reasonable requests for extension, just so everyone is aware. But there was no communication. So I want it very, very clear what they can and can't do. It's less about semantics. This isn't about semantics. It's about substance. What are they allowed to do? If this court wants to call them a limited purpose party, that has to be, well, it's so you can exercise your rights under 4-202.04. And in doing so, this is what you need to do. That's what we're asking the court to do. And I also have some practical concerns that maybe need to be addressed with the court's clerk. For example, are we adding all 23 media entities to the court docket? Will they have access to all of the filings? I have had instances in the past where, unfortunately, parties have been added to a case and still receive documents that are intended to be private or non-public. I'm very concerned about that. So I think it would be appropriate, if they are going to be added to the docket, that it be reasonable, perhaps just the two entities that are requesting, the two conglomerate entities that are requesting, and that there be an order from the court saying if they receive something that they shouldn't have, they notify us in the court immediately and they delete it, they don't review it. At a minimum, I think that's necessary. But I also think it would be reasonable for this court just not to put them on the docket for that very same reason. So we don't think that they should have permanent status in this case. We don't dispute that they are going to be here. They're already here, as we well know. But we do think how that happens is important, and that this court should exercise its authority to make very clear what everyone's roles are here. And as I believe they put in their briefing, that they are neutral observers. Neutral observers. We don't want the chaos that is out in the media in this courtroom. So whatever this court can do to prevent that is what we're asking. Does the court have any questions for me?
No, thank you.
Thank you.
It's not chaotic out there at all. What's she talking about?
All right,
Everybody's
counsel.
getting along on this issue in this case.
Thank you, Your Honor. Just very briefly, I'm not sure what neutral observer is supposed to mean. We have interests in the case. We are here to advocate for openness
Yes,
and
thank
against
you.
closure. And so I don't think that's what counsel meant to imply, but that's the whole reason we're here, is that no one else represents our interests. That
Right.
is straight down the middle of what the intervention rule requires. Just a couple clarifications. Counsel said we haven't cited any criminal cases where this has been allowed. That's not true. We cited the court to 8 different cases, all criminal cases in the state of Utah, where this is the procedure that judges routinely follow, including judges in this building. Counsel said that our role is strictly limited to advocating for what is under Rule 4202.04. I don't think she meant this, but as the court probably knows, that just deals with court records. We're also entitled under governing constitutional case law to advocate against the closure of proceedings. And that rule does not technically apply to proceedings, it just applies to records. So just to be clear, but I think we have been clear, and this is all, I mean, there wasn't a whole lot of daylight between what counsel was just suggesting our role should be and what we've asked for.
Right.
You know, which is just, if they file a motion that seeks to prevent, that wants to classify something as non-public, like they did last night with
Yes,
the
and a month ago,
motion
too.
to disqualify.
Yep.
They were able to at least provide that to us. It's not very hard to send an email. That's all that we've asked for in terms of the notice. And then we have the right to be heard on those issues. And so I didn't really hear from counsel any reason why we should not be granted limited party status in this case, other than just some sort of, you know, confusion on their part as to what that would actually look like. I don't know how the clerk deals with parties on the docket. I assume you guys can sort that out.
The
Typically,
technical, administrative
when we
stuff.
intervene on behalf of the news media in cases, they are listed because they are limited purpose parties. But the court can, you know, if it doesn't want to hear from us on a particular issue, it can certainly say that. I mean, we don't have any interest in weighing in on aspects of the case that don't have anything to do with the public's right to know. And so I didn't really hear an argument against what it is that we are asking to do. Just one last point on, well, two things. One is that counsel's chastising us for filing something late. I mean, this was a stipulated motion that got us here today. We weren't asked to weigh in on it. It was submitted to Your Honor with an order, you know, which they just assumed you would sign because it was stipulated. It was only because this court said, no, I'm not going to do that. I want to actually hear from the parties that we weighed in. So this was not your typical, like, deadline where we were invited to weigh in and just didn't. Last thing is, in terms of docket access, you know, Mr. Hunt and Mr. Judd and I are all officers of the court. If the court says you can have access to things that the parties are seeking to classify as non-public, but you can't share them with your clients until further notice from the court, that's fine. Some judges do handle it that way. Sometimes we just, you know, if they don't concern closure, sometimes we don't weigh in at all. But, you know, when they file things that they say we need to file this under seal and we're not allowed to see it, then the briefing for you is not super helpful, you know. And so typically the way this happens is we are allowed attorney's eyes only access to, you know, documents just like the state and the defendants would be. Their counsel can see things that are non-public, and we don't share them with our clients unless the court orders otherwise. And typically, if the court decides, no, this really doesn't need to be filed under seal, then we can provide it to our clients at that time. But this idea that our clients are somehow going to get access to things that are non-public, that's just not the way this typically works. If they're not public on the docket, if they're public on the docket, anyone can get them. And if they're not public on the docket, then our clients can't get them. And if
Yeah,
there's
I'll
a
show you
procedure
exactly
where we
how
can
this is
see
all
them,
working in a
so
second.
that we can give the court the benefit of briefing substantively as to what it is, then we keep them attorney's eyes only until the court orders otherwise. And that's just typically the way this works. So, thank you.
All right, let's see if we get a ruling today on some of this stuff. Defense back up.
Your Honor, I'm not going to belabor what's already in the briefing. I do think it's concerning to just cite to a bunch of trial court cases without providing any pleadings or context for what occurred in those cases. I can't argue against what happened in other cases. This is our case. Our case is different. This court has already acknowledged it. There are many interests. We have concerns about leaks, information getting out that shouldn't be out. I think
what?
those are valid. And our concern is access. I'm not impugning the integrity of these gentlemen. I'm sure they would act as officers of the court.
So the lawyers won't give it to the
But
media.
the more this court controls the
media lawyers won't
information
give it to
that
them.
ultimately it determines to be private, the more able we are to identify if there are leaks, if there's information that's getting out that shouldn't be, and who did it. So we are objecting to providing the media our pleadings in advance, even just to their counsel.
To their lawyers.
We don't think that's appropriate. I don't see any authority for that. We're asking the court not to consider that.
How can they know what's going on or
And
object then?
We're concerned about opening the door to multiple other entities just filing in on this case, getting involved in the proceedings. We don't know exactly what media means either. So
Yeah, maybe we'll file
our
something.
position is and remains, they can file what this court has authorized to file in the manner this court authorizes to file it and be heard in the manner this court indicates. We understand they're entitled to closure hearings, and I did make a mistake. We agree that they have standing to object to closure as well. So
Good.
they should be able to file those things, but we do not agree that that requires status in our case. So, does the court have any questions?
No, thank you.
They're kind of talking over each other.
All right. I appreciate the argument from all parties throughout this day. I wish to commend the preparation and the quality of the arguments, as well as the civility that is
It was nice, wasn't it?
sometimes overlooked, but I wish to recognize that and appreciate counsel's demeanor and their arguments today. I previously stated when we began that I would be issuing rulings on the first issue. And when I began, I initially said October 14th. It's actually the October 24th audio recording of the closed hearing, as well as the October 24th transcript of that hearing. And so I wanted to create, just make that small correction.
The first closed
But
hearing.
given the in-depth and necessary arguments made in the closed hearing, I wish to take the time to issue a ruling that will say what will be disclosed and what will be kept private, because this court has a duty to do so. And I would rather do it right and take more time than to be rash and miss the mark. I need to be narrow in my approach, and it is an important issue, and so I plan to do that. In regards to the motion for limited intervention and request for notice of motions to close, seal, or reclassify, I also wish to craft my order in such a way that is concise and addresses all the issues, the important issues brought up by all parties. And so I will be issuing that ruling at the same time. And so I will be issuing the ruling in regards to the state's motion to clarify court's pretrial and trial publicity order, and I am prepared to do so. Before I do that, what I want to do is, and counsel is being caught off guard because they were anticipating a ruling today, but what the court is intending to do is, and proposing to the parties, is issuing an oral ruling on WebEx that all parties can attend to. The reason why is I don't want to take a lot of time. These are important issues. I don't want to wait until January 16th. And I want to talk about potential dates. I don't imagine it will take longer than 20 minutes for this court to issue ruling. And I want to get the parties' input in regards to their thoughts of the court issuing an oral ruling on WebEx. And so I'll open it up to the parties.
No objection.
We don't have any objection to that, Your Honor.
Thank you.
We have no objection to that, Your Honor.
Yeah, same.
All right. Well, next comes the trickier part when you have a room full of attorneys trying to find a date that we're all available. To our staff, what dates do we have available for a 30-minute block before the end of the year?
Judge, we do have December 29th at 10 o'clock.
Yeah, make him do that one. I'll be
How
so
does that
mad.
appear? How does that date work for council?
That was 10 a.m. on the 29th.
Yes.
Your Honor, that works for Mr. Robinson, thank you.
Nice.
Same for us.
All right.
Holiday
And to defense,
appearance.
in regards to Mr. Robinson, what is your position on, if it is on WebEx, he would be appearing by WebEx, or is there different thoughts?
Maybe they'll turn the camera on this time. This is
Your Honor,
the,
if we could just have audio only for Mr. Robinson to appear,
no cameras.
since we will not be present. I would rather not have him in the courtroom without counsel present.
All right. Thank you. I appreciate that.
Cameras
So
off.
we will set the court's ruling on those two issues for December 29th at 10 a.m. And note that it will be audio only for Mr. Robinson per defense's request. And to the last issue is, well, before I issue my ruling, I anticipate, and Counsel, are we still on the same page in regards to our January 16th hearing? Are we planning for that?
Your Honor, we are. We believe that most likely what we would anticipate doing is on January 16th, arguing our motion to disqualify the county attorney's office, which was just filed. That should give them enough time to respond to that. And also possibly, we anticipate filing our own motion about the pretrial publicity order that has a little bit different take on it. That should be filed in plenty of time for us to argue that on the 16th as well. I think we have set aside the 30th, and that might be the one we want to save to argue our anticipated motion that's coming about keeping cameras out of the courtroom. And we will, I imagine the media will, depending on the court's ruling today, will want to weigh in on that one as well, and that would give them enough time as well. So that would be January 30th.
All right, and before I go to the other parties, the January 30th date, there was some complications, and so we have to find another date.
Okay.
And so I just wanted to let all parties know before we lock in our schedules, what dates do we have available for a 4-hour setting?
It's okay. My problem.
And Counsel, I appreciate you giving me that roadmap that helps plan, so it allows the other parties to take in consideration dates and filings as well. So
Attorneys
as
spend a lot
staff
of
is
time
doing
waiting,
that,
waiting
they
for
are
dates.
looking for hearing dates. And one of the complications is, as a judge, I have 1,409 cases as of last Friday.
Wow.
And so trying to find a spot is tricky, and I'm grateful for my staff who work so hard to manage that calendar. So
this one's high
that
priority.
is part of the reason for the
Bump the other
delay.
ones.
And we're trying to find a date because this is an important case, as is all of those cases. They matter to me.
Yeah.
Your Honor,
We know.
while we're waiting, can I, if I might just make one point that might make things smoother as we
Think
go
this is the media
forward with
guy?
the sealed filings? Just to Ms. Nestor's point, Mr. Novak earlier mentioned something about a redacted motion to disqualify, and I don't know if that is something that they're planning to file, but I was just going to say, sometimes, what we heard earlier about that particular incident is probably not something that we care that much about in terms of what they would redact. And so instead of opposing the motion to classify, if Your Honor, I don't know if this is the plan already in this case or whether that's what they were planning to do, but if they file a redacted version that, just takes out the stuff they care about rather than closing the whole thing, then we don't have to say anything and probably avoids, fighting over unsealing that document. So I just wanted to say that. I'm happy to confer with counsel if you'd rather us do that, if you don't want to do it.
We can
by
just
way of
agree to
court order, but-
redactions
No, I
rather
appreciate
than
that
fighting over
input.
closures.
I'll hear from both parties, and then we'll get to the date.
Your Honor, I do anticipate going through and seeing what we can redact and working with the state on that as well, and with media counsel, so.
All right.
And we agree that filing a redacted version is a good way to go. We can work together on that. As far as the January 16th hearing, the state will do everything it can to respond to these motions as timely as we can, as expeditiously as we can. I just want to note that that January 16th hearing was set with the expectation, the previous expectation was that defense counsel was going to get us these motions before Thanksgiving. And we just got the motion to disqualify last night. So we'll do everything we can to respond to those as expeditiously as we can and hopefully keep that date, but I'm not guaranteeing that we'll make that date.
All right, I appreciate the heads up. Going to staff, what dates do we have available for, in lieu of the 30th?
February 3rd, good. Close.
February 3rd, morning or afternoon setting?
Can't do it. Who? Move it! Defense attorney whispered. Your mic's on. We can hear you.
That works for Mr. Robinson, Your Honor.
All right.
All right, thank you.
Okay, we'll handle it. You don't have to come.
And morning or afternoon setting?
Either works for us, Your Honor.
All right.
As well as for the state, we're available on the 3rd.
The
anytime.
afternoon would be better because it may be that it reduces travel time.
It's a Zoom meeting,
All
isn't
right.
it? Or no?
Well, it is
That's
always
not the Zoom
nice
one.
when all parties agree. So we
So-
have February 3rd at 1 PM.
In person.
It is anticipated to be in person.
Nice.
And Ms. Nestor, is Mr. Robinson planning on appearing?
Yes, Your Honor.
All right, thank you. All right, that concludes that particular issue about future dates, and I appreciate counsel working with me on that. We have December 29th at 10 a.m. for the court ruling on these two issues, and that will be via WebEx. And then February 3rd, January 16th, I believe that is at 1 o'clock. Is that correct? All right, that's in person as well with, I believe, defense has indicated Mr. Robinson will be present as well. And finally, February 3rd at 1 p.m., and also indicating that Mr. Robinson will be present. And in regards to the final issue, the ruling on the state's motion to clarify court's pretrial and trial publicity order. This is the order of the court. The court issued a protection order regarding pretrial and trial publicity in this case. The order prohibits attorneys who are associated with the prosecution and defense of this case from intentionally, knowingly, or recklessly permitting a witness, investigator, consultant, staff member, or other member of the prosecution or defense team to make extrajudicial statements, which, if made by the lawyer, would violate Rule 3.6. To that end, lawyers participating in an investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams about the prohibitions contained in this order. The state moves to amend or clarify the court's use of the word witness as used in the publicity order because it is vague, ambiguous, or overbroad. The state asserts that there are over 3,000 lay witnesses of the alleged homicide. The state does not know if it must inform each potential witness or each potential and possible witness of the prohibitions in order, or whether the order applies only to witnesses who are members of the attorney's teams, such as investigators or experts. Due to the potential confusion, this court grants the state's motion and offers the following clarification. The word witness, as used in this order, applies to all witnesses who are part of the prosecution and defense teams. This includes any witness, including lay witnesses, whom the prosecution or defense has a good faith belief will be called to testify at a hearing or trial. The court also clarifies that the publicity order as written regulates the behavior of attorneys who are associated with the defense team or the Utah County Attorney's Office. It requires the
reasonable?
attorneys to abide by Rule 3.6 and, in order to deter non-attorneys from making prejudicial statements, requires the attorneys to inform witnesses about the prohibitions in the publicity order. Informing witnesses about the prohibitions in the publicity order is a necessary step. It is
Typo?
One moment as I regain my place as I read.
I do that all the time here, Judge. Don't worry about it.
Informing witnesses about the prohibitions in the publicity order is a necessary step toward not intentionally, knowingly, or recklessly permitting witnesses from making prejudicial statements. The publicity order does not regulate the behavior of any person who is not an attorney associated with this case.
So narrower.
And this order will be signed today.
Yeah, much narrower.
by
Prosecution
myself
wins
and
that.
made public. Counsel, is there anything further that we need to address today?
Nice.
Thanks, Your Honor. Yes, just the matter of having Mrs. Erica Kirk designated as the victim representative in this case. She has filed through her counsel a request to be designated as the victim representative.
Erica Kirk.
And we would like the court to formally acknowledge that request
Nice. Okay.
and formally designate her as the victim representative.
Amazing. That's
And
amazing.
I guess along those lines, I wanted to make clear as well, I think this court stated earlier that there was an alleged victim in this case. And I know that there is case law talking about being careful about how we refer to victims and alleged victims. But in this case, that case law makes clear that those cautions don't apply with the same degree, where it's clear that we have a victim who was killed in this case. We don't have an alleged victim. We have an alleged perpetrator, but we do know that we have a victim in this case.
Somebody died. It was Charlie.
Thank you, Mr. Ballard. I'll hear from the parties.
Your Honor, on behalf of Mr. Robinson, we certainly think it's appropriate for Mrs. Kirk to be designated as the victim representative, if that is the desire of the state, just so there can be no doubt that she's afforded all of the rights assured to her under our state statutes, and we have no objection to that.
Thank you. Thank you to all parties. This court will recognize Ms. Erica Kirk as the designated victim representative in this case.
Nice.
Thank you.
We've got the statute
Counsel,
on
I
that.
believe that concludes our matters for the day.
One
Or
more
maybe
matter,
not.
Judge. If I can take the podium, Judge?
Yes, Mr. Gernander.
The purpose, I want to just give the court an update with respect to discovery. We've done that at
Thank
previous
you. I
hearings.
appreciate that.
The state has received approximately 13,900 files from law enforcement in this case. Approximately
files?
300 of those we believe are duplicates. We have since provided to counsel, as of I believe this morning, 7,951 of those files. For the court's information, we had reached close to 100% had been disseminated as of last week, but we received quite a large batch within the last few days. So we were working on that. We still have a full-time paralegal that's dedicated to reviewing that, organizing it, Bates stamping it, and sending it out to counsel. Of course, there are necessary redactions that are being made along the way. Our next real hearing in this case, second matter, our next real hearing in this case is not scheduled till January 16th. We understand the court's caseload. We understand the difficulty of finding dates for a preliminary hearing. And we would like to make a request that the court calendar a preliminary hearing in this case.
All right. In regards to, and I appreciate the heads up and acknowledging the busy calendar of not only the court, but all of you. What, first of all, how many days does the state anticipate, which helps us in our calendaring efforts?
Judge, given that it's a probable cause standard, and all the inferences go in favor of the state is asking for 3 days. We believe that we can present the evidence required to meet that standard, and that would also allow the defense to cross-examine witnesses and argue that standard.
Thank you, Mr. Gernander. Turning to defense, what are your thoughts?
Your Honor, we were not aware that he was going to make that request today. We do have one more member of our team that's not present that we would need to consult with. I don't know when he's talking about, but I don't see how we can set it until all the discovery has been received. And also, we do need to deal with the disqualification motion, just in case. So it doesn't seem like a good idea to set it before we have the disqualification hearing. We were only talking about a month from now. I think that should probably be resolved before we set any dates. But I am concerned about setting a date when we still don't have all the discovery materials. We have significant discovery materials that have not been received yet, that we know are out there and coming and important. And we have to, have time to review it all and absorb it all. And I am going to be involved in another trial that is not over until the end of March. So that's going to take away my ability to work and process through discovery and communicate with our team. So it seems to me that with the understanding of what Mr. Grunander's trying to accomplish, that maybe we come to the hearing on the 16th with an idea about, we can have some conversations with Mr. McBride and also with the paralegal that's dealing with all the discovery and see realistically when we think we're actually going to have the vast majority of the discovery materials to us and how long it's going to take us to review it all. So maybe we could just come prepared in about a month to try to accomplish that.
Mr. Grunander.
Just 2 points, Judge. Sometimes I feel like we as practitioners sometimes lose sight of the purpose of a preliminary hearing. It is a probable cause determination. The primary purpose, according to case law, is to ferret out improvident prosecutions. So again, it's a probable cause standard. We are working as hard as we can, being very diligent with respect to collecting and disseminating discovery. Rule 16, subsection 2, speaks to the timing of mandatory disclosures. And it is it's a continuing duty. So as far as complete discovery being provided, in a case like this, complete discovery is going to be ongoing until probably trial. There are times when things become available during trial that are discovered to opposing counsel. But it says the prosecutor's disclosures must be made as soon as practicable following the filing of an information, except that a prosecutor must disclose all evidence that the prosecutor relied upon to file the information within 5 days after the day on which the prosecutor receives a request for discovery from the defendant. That's been accomplished. It then says, in every case, all material or information listed under paragraph A1 that is presently and reasonably available to the prosecutor must be disclosed before the preliminary hearing. So we are in the process of that, collecting it as quickly as possible, making any necessary redactions, and moving it to the defense as quickly as possible. But complete discovery is not required before a preliminary hearing. We have to provide it as quickly as possible. We have that duty, and we continue to do that. So we think we can schedule a preliminary hearing and work towards that. I'm aware of Ms. Nestor's schedule. I know she's going to be in trial, I think, in February and March. And I'm probably overestimating the availability of the court's calendar, but the hope would be sometime in April to schedule a preliminary hearing.
Okay.
I'll submit it, Judge.
Thank you.
Your Honor, can I just clarify one thing? I mean, the county attorney has made a decision, very public decision, to announce their intent to seek death the day that there was an arrest, which means that that obligation to provide us with the probable cause for everything they relied upon to charge applies now to their intent to seek death. And we're nowhere near getting that material. So that was their decision to release that. Normally, that decision is not made until 30 days after a preliminary hearing. They made it in advance, and now they've got an obligation to tell me their aggravation and what they've relied on to make this a death penalty case. And we have not received that. So I'm waiting, but I'm just laying that out there for now.
Thank you. I appreciate the arguments from all sides. I do not find there is any prejudice in setting a date for a preliminary hearing. It is not set in stone, and it certainly can be moved. I recognize that the parties have a lot of obligations, but I also recognize the importance of this case moving forward, and if nothing more, then this is a goal for the preliminary hearing. If it needs to be changed, the court understands that. That is what happens a lot in the criminal calendars and
Anchor it
criminal
in.
dockets.
So this doesn't continue
What
to
is
get kicked down the
a
road.
date that we may have available for a 3-day setting for a preliminary hearing?
So a preliminary hearing is like a mini trial. I just looked this up about how Utah handles this, and apparently they do them. In many other states, you would indict him by grand jury, but apparently Utah is very disfavored to use grand juries.
Not have any in July. We have some in August.
All right, let's take a look. So counsel, well, what dates in June?
June.
June starting on the 15th.
June for a preliminary hearing, not a trial. It will feel like a trial, but it's just to establish probable cause.
All right. Counsel, I'll turn to you. Again, this is a goal. This is not a date that if we can't meet, there's any prejudice that will be attached to a party. In regards to May 18th, how does that tentatively look for
May
counsel?
18th.
May or June?
May 18th is the first date, I believe.
Looks good to us. We're available.
So 18th, 19th, and 21st, just to give you the full range.
The state can make those days work, Your Honor.
Okay, perfect. Your Honor, we have availability the May 18th with the understanding and the appreciation that if it's not feasible for us to get done when we need to get done prior to that, we would ask to push it back. But we don't have conflicts at this time.
All right, thank you. So May 18th, May 19th, and May 21st.
All right.
And it will be in person, and do we anticipate, if that date moves forward, Mr. Robinson being in attendance?
Absolutely.
All right, thank you. I just want to put that on the record as well. All right, I don't want to be presumptive, but is there anything else? All right. Counsel, thank you again for your hard work today, and I wish you all, Mr. Robinson, a good afternoon. Court is in recess.
All right.
Thank you.
All rise. Thank you, Judge. All right, so honestly, that was a very good proceeding to have witnessed. And just to back up a little bit, we watched a lot, but earlier they were in session. You can see they were in session. The court kicked off, and then they had a closed session. So the judge, made appearances, please. This is rewinding all the way back. They talked about cameras in the courtroom. Then they closed it out. Okay, so like 6 minutes in, they closed it out. Then we waited. They had a whole secret hearing kind of behind closed doors. We didn't know much about what was going on. Then they came back, and we just caught in on that. We jumped live a little bit early, and we picked it right up. So they brought Tyler Robinson back in, but you can see this is where the camera was originally. Okay, so the judge comes out. He says, yeah, we're going to allow cameras in the courtroom, but we're going to move it to the other side. And they'll move it again. They're all kind of in weird spots right now. So let me just show you what happened where the camera was earlier. Judge comes out, and they had the cameras on this side of the courtroom. And there's Tyler Robinson, the defense attorneys, their Hintwater prosecutors over there. Man, we got some armed up dudes in there. So high security, National Guard or, local, I'm not sure who they are exactly, but so some other angles of Tyler Robinson. Looks like he's got some of that furry consequences on his lips as he's been in there. But the judge came out and then moved the cameras around. And so here is how some of that sounded when the judge came out from earlier in the day. Now we're going to break down what happened in this hearing. And I've got, all right, so maybe AP just killed it or something. Or they cut back.
The court has the highest.
All right, so they moved the cameras. Cameras have been allowed in the courtroom. We've got questions about some other orders, about media intervention and things like that.
Degree
But
of-
we saw that they were just battling and duking it out over a date for a preliminary hearing. And I wanted to pause on that because this is a little bit in the weeds, but I think it's interesting and important and different than what we've seen in other states. In Arizona, for example, oftentimes a person will get arrested and they'll be charged with something like this, an information or a criminal complaint. It's the prosecutor making the charge, but then they'll get indicted by a grand jury, okay, so that you don't have to have what we just discussed in this court proceeding, which is called a preliminary hearing. So there's generally two ways to bring felony charges. Okay, one, you go through a preliminary hearing to prove that there's probable cause, or the defendant can waive that hearing. There's things that can happen. Or, as we regularly see, somebody gets indicted. But apparently in Utah, and I didn't know this, I'm not licensed or I don't practice in Utah, but we're, of course, licensed in Arizona and California, so we're right around the corner from them. But I was asking Gemini about this. I'm saying, what's going on over here? Why are we actually going to have a preliminary hearing? And a hearing is a probable cause determination. So the cops will come in, there'll be a short presentation of evidence. It will be like a mini trial, and the judge will decide whether there's cause or not, and then the case will progress forward. Now, many other states want to avoid doing that. Like, you don't want to have a mini trial in front of the judge and all this stuff. So they'll just indict by grand jury, but apparently in Utah, they just don't do that. So Gemini answered this, and if you're a Utah lawyer and we're wrong, let me know. But Utah does not typically use grand juries because the state operates under openness and adversarial testing philosophies. While Utah does allow for grand juries, they are incredibly rare, and I was trying to find a rare example of this, and I found one right here from this article from Standard Examiner. This is back in 2020. Utah's rarely used grand jury system is scheduled to come out of hibernation for 1 day next month in Ogden. And they can do this like once every 3 years. They're going to supervise a panel here. So they just don't use it. So we might get some good activity on this case. I mean, in other words, we may get more of an insight into all of the evidence that many people are speculating about out there earlier than we think. Like, we don't have to wait for a full-blown trial. We'll get some more materials that come out in a preliminary hearing, like a mini trial. So, and we just saw that might be happening in May. So sooner than we ever thought. So grand jury proceedings are secret. The defendant is not present. Lawyers are not present. Public cannot watch, which is why prosecutors love it. They most of the time go that way for very serious cases. But the preliminary hearing standard in Utah is the standard. Proceedings are public. Evidence is presented in open court before a judge, allows us all to see. Now, the difference is in a grand jury proceeding, the defense is not there. So you can't object. You're not saying you're lying, or you can't even see anything. In a preliminary hearing, you can cross-examine. You can have state's witnesses, and they can cross-examine the state's witnesses. So in other words, we might be getting some interesting developments in this case much sooner than we think, given the fact that they will actually be going to a preliminary hearing. So we got dates on that. That's going to be coming up in May. And there's a bunch of other filings that are happening behind the scenes. But we've got some other updates that I wanted to share on this. So we've got the court docket. I wanted to kind of show you exactly what they were fighting about today. So this is the docket. This is the Charlie Kirk assassination case, Tyler Robinson, straight out of Utah. You can see state of Utah versus Tyler James Robinson. And there was a hearing. So he got charged by information back on September 16th, right after the assassination. He got public attorneys appointed to him. And then there was a secret hearing, basically. And that happened later in October. So like October 24th. Look at this. Private, right? We got these private hearings that are being not publicized. So the media then was weighing in on this. We had another one here, sealed. Minutes sealed. There was a closed hearing on 10/24. It was not public. The media said, what the heck? How are you having these closed door proceedings? And we were screaming the same thing because the prior two court proceedings that we saw on September 16th, 2025, we saw a very brief camera on appearance from him. But then on 9/29, cameras were off again. Then on 10/27, cameras were off again, and we couldn't see this dude. So they finally brought him to court, and we got to peer inside. But now you can see there were even more filings. We've got these in-person dates were scheduled. We fast forward. We're now in December. A lot more stuff. The media is now fighting in here. So the media, defendant Tyler James Robinson was responding to this. In-person review hearings have been scheduled. And then recently, so like last night, bunch of stuff got filed. Private, right? On 12/10, private. Motion to disqualify as private and a request for closed hearing. Motion to disqualify as private and a request for closed hearing. So the defense is trying to throw off the prosecutors, the current prosecutors, for some reason. We can't see what it is. All got filed under seal. Media wants to be involved in it. The judge is saying, we'll probably let you be involved in it, but to what extent? Like, in other words, does the media get to see these things right now? Does the attorney for the media get to see these things right now? Or can they just see maybe the title and access the public docket just like we can access it, and then lodge an objection? Say, wait a minute, we want to read that. if that's the case, then every time we have to have a closure hearing, which is exactly what we had today, to have a debate about whether we can open the hearing, open the proceedings, or open the records or not. So we want transparency in this case, man. I think that transparency and more evidence slowly being revealed is going to turn the temperature down on all sides on this thing. We just have to be sober about it and patient about it and let, the process work through. And I think we're going to get some more evidence on this sooner rather than later. I know that May is a long time away, but we'll have some evidence. It sounds like that is going to come out. And so we'll be able to piece some of that together. Now, the other interesting development today, which I'm a little bit surprised it took so long, can't believe this isn't already a thing, is they officially made Erica Kirk the victim of the case. And we thought that probably had already happened because, she was the victim of the case. But many states, including Utah, have a victim's Bill of Rights. And so now the question is, what are the Bill of Rights? What do they say in Utah? I pulled it up as we were listening to the court proceedings. And here is what now applies to Erica Kirk, who's been appointed as the official victim of the assassination. The victim's Bill of Rights is the following. Subsection 1A. Victims and witnesses, so now Charlie Kirk's wife, Erica, has a right to be informed as to the level of protection from intimidation and harm available to them, and from what sources as they participate in this proceeding. So oftentimes what happens in these cases, so let's take a domestic violence case, for example. Generally, the dude is arrested. Wife says, husband hit me. Wife is the victim of the domestic violence, right? What if the husband hires a defense attorney? Can that defense attorney contact the victim to tell her not to prosecute the husband, right? No. They would say that something like that, they can participate in this without being intimidated by some defense attorney. You can't be extorted. You can't be bribed to dismiss a criminal proceeding if you're the victim of a crime. And this happens all the time anyways. What often happens a lot in domestic violence cases is that other person just doesn't assist in the prosecution. So in this case, the wife doesn't show up to the trial. She is the only witness to the misdemeanor. If it's a felony, they may go, drag her butt into the trial. But if it's a misdemeanor, cops show up. What happened here? He hit me. Okay, did he? He says, no, I didn't. Okay, it's he said, she said. Cops saw nothing. Neighbors saw nothing. Nobody saw anything. So unless the victim comes to court to testify against the husband, they have no case. So they know that. So they create victims' rights rules so that defense attorneys don't go and bang the doors on all the witnesses and say, can you not come to court on a trial next week? How about you go over to Hawaii and have a nice trip out there? So victims have rights. Now, victims and witnesses, including children and their guardians, in this case, Erica's children and Charlie's children, have a right to be informed and assisted as to their role in the criminal justice process. All criminal justice agencies have the duty to provide this information and assistance. And when I was representing people, represented the defendants, and so the victims would come to court regularly. And many cities and many courts would have a victim's advocate in the courtroom for them. So like they would come here, backdoor Judge Dugan. I think that those victims were there with a victim's advocate so that they can have help through the process. And there are victims' lawyers that also work in the criminal justice process so that victims can be properly represented so that prosecutors just don't throw their interest by the wayside. And Erica, has not done that in this case, as far as we know, but now she's officially under these rules. Victims and witnesses have a right to clear explanations about relevant legal proceedings. These explanations shall be appropriate to the age of the victims and witnesses. All criminal justice agencies have a duty to provide these explanations to the victim. So Erica Kirk will have more official interface capability with this investigation now that she's officially a victim. Victims and witnesses should have a secure waiting area that doesn't require them to be close to the defendants in separate rooms. Victims may also seek restitution and should have knowledge about how to do that. Now, Tyler Robinson, what's he going to pay for the killing of Charlie Kirk? Victims and witnesses have a right to have any personal property returned to them. Victims and witnesses have the right to reasonable employer intercession services to minimize loss of pay where appropriate. Victims and witnesses, and particularly children, should have a speedy disposition of the entire criminal justice process. All involved in public agencies shall establish policies to encourage a speedy disposition of these, and they have a right to timely notice of judicial proceedings. They are to attend, and timely notice of cancellation. So all notice about these hearings, Erica Kirk, if she wants to come to them, she can. Criminal justice agencies have the duty to provide these notifications, defense counsel as well. Now, in addition to this, if it's a sexual offense, it wasn't, testing for HIV, all those things. If you're a victim of a sexual offense, all sorts of other things get triggered, and you get more support for being attacked and more. So all of the rest of this looks like it's about sexual assault and offenses there, victims designee, and none of the rest of that applies. So Erica Kirk officially now the victim of the case, formally added to the record. And there were some other filings that came out that they were arguing about. I'll just show you some of the highlights here just so we can get a little bit of taste for the motions practice here. But this one came in, we saw the back and forth basically from everybody. The media wanted to intervene. We heard his argument, so we don't need to spend a ton of time on it today. But basically, he was saying today, we have a right of access. The media has a right to come in here and see what's going on. The proponent of a closure bears the burden. And there are many other less restrictive alternatives. Redact some information. You just can give it to the lawyers. The lawyers of the media, interveners, don't necessarily have to be provided the actual document, but the lawyers can and will be good faith stewards of the court's rules. And officers of the court won't violate your order. So you can give us the materials, and if we can't disclose it, then we won't disclose it. Saying this motion marks the first time that this court will confront what is likely to be a series of requests. They're going to continue to ask to close the proceedings from Tyler Robinson's side. And we didn't get much closure today. We had a little brief period of closure, but got to hear the rest of the case, including how much evidence, gobs of evidence, thousands and thousands of files are now being dumped into Tyler Robinson's lap from public view, based on generalized assertions that pretrial publicity will make it impossible for a fair trial. It's like, give me a break. Tell me about, and people will say, well, this is a state level prosecution. So the prosecutors are freaked out and they're very nervous about pretrial publicity. It's like, we just saw Luigi Mangione over there in New York go through the whole thing. His pictures were all over the place. Same thing. Rewind the clock just a little bit to Kyle Rittenhouse, images all over the place. Derek Chauvin, scapegoated, his knee on the neck. That was on repeat constantly. So don't say that pretrial publicity is damning. If we can turn the cameras on for Derek Chauvin, we can turn them on for Tyler Robinson. And the media has a right to be a participant because they're working on our behalf, the American public. And by the way, more transparency, I think, is going to calm the temperature down on this whole story. So these kind of blanket claims are not new. They arise in every high-profile criminal prosecution, often at alarmingly early stages. They seek to create a broad prophylactic with sealing orders and speculative predictions about what some jury pool might see. And they never want to bring that up about voir dire. Just ask the jurors. Do you know anything about this case? No, I don't. Oh, perfect. You do? Yeah. Can you set it aside? What do you know? How long have you been following it? You're telling me you can't find some jurors in Utah who don't watch the news? I'm sure there are many. So this particular issue arose after we were battling about this because the state and the defendant stipulated to a closed hearing, and we never got to see that one. And the judge is going to weigh about what is unredacted and what is unsealed, but they were prosecuting this behind closed doors. That's why we flipped out about it, saying that they were talking about his attire. They were talking about judicial restraints, and the court acceded to that request. The court closed it without the benefit of briefing or objection from the news. That's why we flipped out. If you're going to lock stuff down and kick the public out, we have no choice but to fill the void with our own explanations. If you give us an explanation or help nudge us towards a good explanation, that's more helpful than just doing all of this behind closed doors and telling us that it's all on the up and up. That was followed by another stipulated request. Again, the prosecution is agreeing with the defense. There's something icky about that from the beginning. They agreed to seal the entire audio and transcript of that hearing without regard to any of its actual content and without any argument by the parties about why the content of that hearing warranted this extraordinary remedy. How come? They had to seal the whole thing up and they had to do it without even notifying the media about it. That motion is still currently pending. Now, fortunately, after this court declined to sign the blanket sealing of this, the state and the defendant appear to have retreated from their original positions because they got caught by the media. This is the point. It's an adversarial system for a reason. Prosecution and the defense, they're not supposed to be playing patty cake with each other, okay? They do all the time, but they're not supposed to. So when it looks like they are, and they have a stipulated, meaning an agreed motion, any objections? No, we agree that we're working on this together. To seal everything, that feels like a problem to us. Even if it's not a problem, then why don't you just tell us what it was about? You don't even want us to ask about it. So the media found out, they screamed in here, and they have retreated from that. Now they're only asking for some redactions. Yeah, albeit based on a 2-word, unexplained justification that does not even remotely approach the constitutional showing necessary to conduct this court's business in secret. Erica Kirk wanted this open and accessible by the public. Now she's a victim, so maybe now they'll consider that. But while it is helpful for the parties to have now limited their closure request to only certain portions of the transcript, this is why we're upset. This is why we needed to intervene. So to that end, media interveners submit this opposition to provide the court with a comprehensive discussion about the constitutional standards. In the end, every high-profile criminal prosecution has significant pretrial publicity. It's not an excuse to seal it off from America. And there is a reflexive tendency in every case to say, it must be the first of its kind. It's unique in a way no one's ever seen before. And so nobody can see it. We have to conduct a quasi-secret trial. Get out of here. The long history of our criminal justice system counsels otherwise. Courts do the public's business. This is not the first high-profile criminal trial in Utah, and it's not the last. So stop acting like babies about it. Time and again, our courts have managed the delicate constitutional balance, and this case is no different. So allow us to participate in this matter. Now, more background on this. On October 9th, Tyler Robinson moved for leave to appear at in-person proceedings in civilian clothing and without restraints. We saw that happen today. Then there were safety issues, and he asked that the hearing on the motion be closed to the public. Now, when the state responded to the closed hearing, the state asked, this is the media writing, that its response be classified as private. So then the prosecutors, who were asking for virtual hearings because they didn't want to put on pants, I guess, and go into court, they said, we want our response to be private too. Nobody can see it because there's information about security measures. Okay, so the court granted the motion to classify. Then they had a closed hearing on October 24th to talk about the civilian clothing motion. You need a closed hearing to talk about civilian clothing. Then in the days leading up to that, something unexpected happened. Both the state and the defendant spent portions of their pre-hearing filings asking the court, playing patty cake together, to close this proceeding to the public altogether. They said, Mr. Robinson agrees with the sheriff the court should limit media coverage, videos and photographs at least, so his appearance is no longer the subject of interest. Are you kidding me? His appearance is no longer the subject of interest? This whole case is essentially an identification case. He changed clothes. He was not the same person, walking on the campus as the person jumping off the roof. And his parents turned him in, or he turned himself in, and all. Is the identity of this person who they say it is, based on the surveillance footage and all of it's about identity specifically. They don't want the public to think about that. They just want, all of us to be shut out. Now, while the court declined to consider that request without briefing, its order suggests that at least some of the hearing was dedicated to the topic of restricting public access to this proceeding altogether. And we don't even know what happened at the hearing because it was sealed. Then on November 3rd, Tyler Robinson filed a follow-up motion, a stipulated motion that they also wanted private. Now, this time, the defendant, Tyler, with the stipulation of the state, the prosecution agrees, they said the court should shield from public view the entirety of the transcript. You can't see anything that happened on 10/24. It must be classified as private. Now, despite the stipulation by the parties, this court, again, properly declined to sign that order. recognizing we have to hold a hearing before I can just seal these things. So finally, then last week, on December 4th, Tyler Robinson and the state, again, they filed what they called, curiously, a joint status report working together that retreated from the wholesale sealing in the original motion in the first place. That filing listed 22 different sections of the transcripts that they would just want to redact, each identified with no more than 2 or 3 word descriptions that don't even explain the redactions at all. So now they're like, oh, the media caught us. We can't do these sealed things. So now we'll just redact a bunch of things. They say this is ridiculous. Public and news media have a right to access. All of these cases support that. It extends to this file as well. And it's a constitutional principle that's moored in our history. And denying access precludes public scrutiny of the judicial process. It creates an impression of unfairness and secrecy, even if they're fair, even if they're above board. We can't see it. You have a promise to make these things accessible to the public. You're doing the work on behalf of the public. The public wants justice in society. The courts, the FBI, the prosecutors are working on our behalves. So we demand access. To overcome the public's constitutional right of access, and when the prosecutors, who are supposed to be protecting the public, when they undermine our right of access that is guaranteed to us by the Constitution, we start to have doubts about their capabilities and about their integrity. It's constant. Why are they violating our constitutional rights? So now in their recent stipulation, this is the media writing, the parties identify without any explanation 3 interests that they say will justify their redactions. 1, courtroom and jail security interests. Like, okay, I don't need to know what the security codes are, what the rooms, the back entrances look like, or like the transportation discussions about transporting him from the prison or the jail back over to the courts, like what route. I don't need to know those things. Fair trial rights. We absolutely want to know what's going on there. What is the argument about fair trial rights? Because we have standards about what those fair trial rights are. And the question is, are they dropping above or below those? And is there a double standard that's being applied? What's a fair trial right for Tyler Robinson? Are those the same fair trial rights that Luigi Mangione gets, or that President Trump got when he was being prosecuted 4 times criminally, or that Derek Chauvin got or Kyle Rittenhouse got? We want to know. We're the public. We demand action and the enforcement of standards, so we should have a participation in this. Also, privacy interests. Yeah, we know. All of that should be debated in public. Now, media interveners do not contest that certain security interests, so long as they're narrowly drawn, can be sufficient. But the remaining 2 interests are ridiculous, as we just said. So they're endangering the public's access, and lots of explanation, lots of case law. All those blue highlights are all case law, lots of rules. So, we understand we have a right to access. They're explaining it in great detail in case the judge doesn't know. I think he does. I think this judge is going to allow the media more access than the defense, and it sounds like even the prosecutors wanted. People in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. Thank you. Supreme Court said that. People in an open society do not demand infallibility from their institutions. We know our institutions are filled with humans, and humans are flawed, but it is difficult for them to accept what they are prohibited from observing. We're tired of being told what the truth is by liars. We've been lied to repeatedly on some of the most important issues. So we want transparency. We're promised transparency. We're due transparency. That's all we're demanding. So for all these reasons, this court should deny the stipulated motion to make this stuff private, redact only the portions that meet the standards, and stop denying the public's constitutional right of access, signed by Jeffrey J. Hunt. Shout out with C. Michael Judd on behalf of the media. And the judge will now weigh in on this, and we'll have some other court dates coming soon. So as we can see, the next court dates, let's refresh this so it can get our latest documents or our latest dates scheduled over here. As we can see, January 16th, 2026, we're back in person. But we're going to have a WebEx court ruling with the cameras off, 12/29, to close out the year, to get rulings on some of these things, how the media can intervene, and more. So we'll keep our eye on this one. Today, I want to say I think that this court proceeding was very good. It's a little bit refreshing and reassuring to see the mechanics of what's going on inside the courtroom rather than having them. And I think you can see it very clearly. We can see and feel confident that the process is moving forward when the cameras are on and they're in person. When it's all on WebEx and everybody's just kind of racing through the proceedings, we feel like there is something that is being left out. So we're in favor of more transparency. We're grateful that the judge opened the cameras up. I know there's a lot of intensity around this case, as there should be, by the way. There should be a lot of intensity around this because Charlie Kirk was murdered in front of all of us, and we demand the truth and prosecutions held to the highest absolute standards. And as the public, we have a constitutional right, and so we're going to demand that we get it. So we're going to keep covering this, my friends, with a hopefully sober, focused approach, focused on the documents, and we hope that you join us as we do. All right. That was an interesting afternoon, no doubt about that. Now, we have another segment queued up, but I wanted to just see what other questions may have come in on this while we're here, because that was a lot that we just talked about. So maybe there is something relevant that, oh my goodness, look at all these membos we got. Holy moly. That's a lot. Okay, we got this one from Lawful. Thank you, my friends. We're going to welcome a bunch of new members in a minute. We got another segment coming up, but just a quick pause. Waffle Salter says, I'd be interested to hear how you would defend this person if you were his lawyer. And could call this all try in a person, especially since there appears to be camera footage and a ton of SM coverage. From Waffle Salter. Waffle, thank you for the nice dono. Well, I mean, I think like any other defense case, right? We have a presumption of innocence in America. Everybody's entitled to that. Even the most reprehensible of people are entitled to that. So the burden is on the prosecution. Now, this case is a little interesting too, because there's like a pseudo confession kind of thing that's happening with Tyler Robinson, right? Apparently he turned himself in. No real jail footage of that. Or is that the J6 case? I mean, that might be the J6 case. But there is a voluntarily acquiescence to the law. Like they didn't go track him down and catch him. His parents allegedly and him went down to the police department and turned himself in. So if that is the case, is that a confession? Did he confess? We don't know, really more details about that, but that would maybe change the strategy. Like if you've got a full blown confession, they may not be trying to get him, exonerated. They may be trying to spare him the death penalty. So the strategy could change based on, are you trying to negotiate a plea deal or are you trying to beat the charges entirely? And if the evidence is that he went and turned himself in and says, yes, I did it, here's all the evidence, and there's gobs of evidence, then the logical conversation with the client might be, we can go to trial on this, but like they're going to take your confession that they've got on recording and just bring it in. So the jury's going to convict you and then the judge might give you the death penalty. So we might want to have a different approach and a different strategy, which is to just, defend this case aggressively, make them prosecute and, put up the evidence. Maybe there is a mistake with something or there is a better alternative explanation. But if they don't want to have a full blown trial, they could offer a plea deal, right? And now the public would have to see what we think about that. A plea deal that spares the death penalty. Would that be politically palatable for the Utah County Attorney's Office? They came out talking about the death penalty. They may have done that strategically so they could pull it back off and give him a plea deal for a life term or, several life terms. He goes away forever. We avoid a trial and everybody on the internet is perfectly satisfied with the outcome. We got great question. Thank you for the nice dono, Waffle Salter. But it would be the same thing you're seeing here. You just fight every hearing, every issue, and just be obnoxious as hell. Michael Manson, what's up? Hey, Merry Christmas. Okay, so my friends, any other comments on the Charlie Kirk thing? We got a J6 update as well. Charlie Kirk update, man. I miss Charlie, man. I really do. Philip Butler, he showed no emotion about her talking about death. Yeah, he did not. He did not. He almost kind of looked like he was unperturbed, just kind of sitting there, like going through the motions, like he's sitting at, a car wash or something. Sharpie guy, Rob, is it me, just my point of view, or did the defense appear to be procrastinating everything? Well, yeah, they want this to go out as long as possible, right? Generally speaking. Is that a tactic or perhaps unprepared? If I was Robinson, I'd start sweating about my lawyer just not up to task. What say you with your skills? Still, what is happening with the defense? It just seems weird. Yeah, so you can have a split on this. A lot of it depends on the case. Like in a DUI case, sometimes you want to race to trial because you can race to trial before they get the blood results back, and then it puts the pressure on the state, and they're not prepared, right? So you race to trial, you have a speedy trial, you really want to go fast because it's to your advantage as a defense attorney because the government will not be prepared. And if you can get the judge to say, no, yeah, you're right, you want a trial in 3 months, you got it. And then the state comes back like, we're not ready. Well, he's got a speedy trial, right? So then you can fight over timing in that regard. But in other cases like this one, where there's a death penalty on the line, they're going to be probably not racing to a resolution on this. They're going to say, we need more discovery, more evidence. The defense is going to want to file a gazillion motions like we've seen before. They're already doing it. Motion to disqualify the county attorney. There's going to be a million other motions. So they're not in a real race, especially if the evidence is bad. Like the worse the evidence is, the less inclined they are going to be wanting to race to a trial. I think from their perspective, from a defense attorney's perspective, you honestly probably want to delay this as much as possible so that the political fervor dies down. You want everybody to move on and forget about it, which we're not going to do, but that's the stretch. 3 years from now is when you want the trial to be starting, right? So that most people are moved on, something else is happening, everybody's focused on the 2028 election or something like that, or whatever is coming up next 3 years from now. But yeah, that makes sense to me from their perspective. Sharpie guy, good to see you. Yeah, it's I don't think it's really weird. I think it's pretty standard stuff that they're going to want to delay it out, especially if the evidence is terrible, because what benefit is there to race to a trial if you're going to lose? Chubby, so basically Utah rarely uses grand juries, but they don't like secret hearings. Yeah, I know, it's very contradictory. They don't use grand jury proceedings because it's too secret. Instead, once you're actually criminally charged, they just close down the court proceedings. So Utah rarely uses it because they don't like secretive hearings unless it's their own secretive hearings. Sure, it makes sense. I know. Defense was probably being nefarious, asking for the closure, but I feel like the prosecution was just being lazy because they didn't want to have to spend the time redacting. Well, I don't know if that might be even worse. They're just lazy. They don't want to redact the document. Do your job, put your pants on, go down to court. Enough with the Zoom meetings. It's a felony. Get down there. All right, so good stuff. Thank you for those. We're going to come back. We're going to welcome our new members and all of the other things, but we do have another update on the J6 alleged pipe bomber too. So we've got that one queued up. And yeah, let's get into this one. Let me make sure we've got our red pen out over here. And this case is getting locked down also with a protective order. So let's see what we got here in the case of Brian Cole. The alleged pipe bomber gets a little bit more time. The government and the defense agreeing for a postponement of the scheduled detention hearing that was coming up soon, saying we have a boatload of discovery that has now been turned over to the defense. Brian J. Cole Jr., the alleged pipe bomber, the so-called, according to his family, autistic DoorDash brony who lived down in the basement, who had a chihuahua who passed away, now charged with allegedly planting both pipe bombs. 2 counts, though, not 4 counts, just 2 counts. Says the United States is now respectfully moving the court to exclude time under the Speedy Trial Act. We've got speedy trial rights. You got to go fast. You can't have cases drag on for 10 years. But now we want that time to be excluded from the total amount of time that we have to allot to the speedy trial. We can have plenty more time from the date of his arrest on December 4th through the date of the detention hearing, which the defense has requested to continue. So the defense attorneys are saying, we need more time. We're not going to challenge detention. And they're submitting this in one single motion, reflecting relief sought by both parties. Now, the U.S. attorney who is submitting this is Charles R. Jones. It's not Jocelyn Ballantine, who we've had some concerns about. But they sent this one in. They said, all right, on December 5th, Brian Cole Jr. was presented on a criminal complaint following a federal arrest. The court ordered that he be detained pending a detention hearing. The court scheduled the detention hearing for next week on December 15th. On December 8th, though, the court contacted the parties to ask us. Clerk said, "You guys ready to go for this detention hearing on 12/15?" Now, in response to the court's inquiry, the government met with the defense attorneys, prosecutors, and defense, again, having a conversation. It is normal for them to talk. And the defense, has requested that the government represent the following to the court in this motion. The defense requests that the court continue the detention hearing in this case that's currently set for 12/15 to allow the defense additional time to review the significant amount of discovery that they got from us in the J6 case. The defendant consents to the exclusion of time, so they'll waive that time, not demanding a right to a speedy trial. We say don't want that. The government does not oppose this continuance, and the parties request that the detention hearing be reset for December 30th. Man, so we're going to have a jam in December. 29th, we've got Tyler Robinson. 30th, we're back with Brian Cole Jr. Under 18 U.S. Code, an indictment must be filed within 30 days after an arrest. Here, that period, though, can be continued. Here, he was arrested under an indictment here, January 4th, 2025. Okay. However, this indictment can be continued if the court finds that the ends of justice are served by taking such action if they outweigh the best interest of the public and the defendant in a speedy trial. So we need more time. If we don't do this, the defense is going to be at a disadvantage. The continuance is going to allow the defense reasonable time to review all of the voluminous initial discovery, and that will give them the opportunity to prepare for the detention hearing, which again, they're asking to continue. So for these reasons, we ask that you exclude the time that you might count against us under the speedy trial rules and allow this to proceed forward. Now, they're also, the DOJ, submitting a request for a protective order. And let's see who signed off on this one. That's the order that is proposed. This one, again, from Charles R. Jones, not Ballantine. They say, the U.S. government is now respectfully moving this court for a protective order in the J6 pipe bomb case. The United States and Counsel have reached an agreement for the protective order, and here is what we think it should be. Going over to Makshila Upadhyay, the Indian-born judge that Biden appointed from Janine Pirro's office, saying, here's what we think should happen. We're dumping a bunch of January 6th evidence over to the defense, but we do not want them to share this with anybody. So order them to protect it. Their defense team includes everybody you could expect: investigators, attorneys, paralegals, expert witnesses, friends, families. It does not include them. The defendant, it does not include the defendant, Brian Cole, or his family members or friends or associates, so they can talk. The defendants and the legal defense team shall not copy or reproduce this to them, and those copies shall be treated in the same manner as the originals. Don't disclose any notes or any more of these other things. We're also designating materials as personal. Personal identifying information includes any of these things: tax returns, telephone numbers, email addresses, witness security, mental health records. We got a big question about that. Is he autistic or borderline autistic, like the family said? No sensitive materials may be disclosed to anybody other than the defendant, the legal defense team, potential witnesses, and more. So the family can't get information, but they are not covered by, this order. Potential witnesses and their counsel may be shown copies of these materials, and nothing shall be disclosed without permission of the court. Now, absent prior agreement, no party shall disclose any sensitive materials, and they shall not be disclosed in open court, although they'll be designated as sensitive if necessary in court. Sensitive materials must also be maintained and in custody and control of the defense attorneys, ensuring that they are not disseminating them. This order does not apply to materials that are or later become part of the public record in the J6 case, were derived directly from the defendant, or that pertain solely to the defendant, like social media records, digital device downloads, and other things. If there's a public nexus, then we can see it. Materials that the defense team obtains by other means other than discovery. So this is interesting, yeah. It's not as locked down as I think it could have been. If the defendant is incarcerated by DC, Defense counsel is authorized to give him a set of the discovery. And if it's designated sensitive, he can't get it. He's got to be moved to a different place to view the sensitive designated materials. The parties shall make a good faith effort to resolve any dispute about sensitivity before coming to this court to have me weigh in on it. Nothing in this order prevents modification, and both sides have their same obligations under the rules for disclosure and discovery. So this is the proposed order that's going over to this judge, Makshila Upadhyay, the Indian-born judge that Biden appointed, who's now in charge of the J6 case of the alleged pipe bomber. But those are the two filings there. Let's do a refresh over on the docket to see if there is anything else that has dropped. Oh, the motion to continue was granted. It was stipulated. We expected that, but she turned it around quickly. So the detention hearing in the request that we just read has been granted. Continued over to 12:30, 1 p.m., courtroom 7 in front of a magistrate judge. And there should be a bunch more filings there. And that will be an interesting one. Like, these are substantive hearings. So the transcripts and a bunch of things will be good to get our hands on. But meanwhile, we saw that Julie Kelly also flagged this post for us regarding Jocelyn Ballentine. She was the woman who was prosecuting this case. And she said, you know, the more I learn and hear about Jocelyn Ballentine, the head of the Proud Boys prosecution team now handling this Brian Joel Jr. case, the worse it gets. And Trump was asked about this in the cabinet meeting earlier this week. Ballentine also handled the investigation into James Wolfe, the former Senate Intel security chief who leaked the Carter Page FISA to a few reporters, including his young girlfriend. Despite evidence Wolfe unlawfully shared this info in an effort to destroy Page, he got a slap on the wrist, pleaded guilty. Nothing really happened. So, of course, we're going to keep our eye on this case, another bombshell case that's happening right now. But we saw earlier this week that the Select Subcommittee on January 6th sent a letter over to Carlin Younger. Carlin told the FBI, this woman, we talked about her earlier this week, she told the FBI that the pipe bomb behind the RNC had to have been placed on 1/6. Remember, we have a competing thesis on this. The standard theory is that the pipe bombs were dropped off on 1/5 the night before. But of course, they only had 60-minute timers on there. So how are they going to explode on January 6th with a 60-minute timer on them? Then we have Carlin, who said she went down to go do laundry. She went down to start her laundry. No pipe bomb. Went back to pick up her laundry. Oh, pipe bomb. So something happened in the interim. It was placed actually on 1/6. She said she started her laundry at 12 p.m., went back to pick up the load at 12:40, and saw the pipe bomb. A Secret Service K-9 also did a sweep of the DNC around 9:30 a.m. on 1/6, and they didn't detect the bomb either. This is why we need to talk to Carlin and many others. Now, maybe her memory's bad. Maybe she just didn't notice it, right? You walk by stuff, you're like, when the hell did that house do that? They did what to the door? What the heck's going on over there? Didn't notice it. You went by 100 times, didn't notice it, suddenly notice it. And that is factually inaccurate from when it was originally put there, right? So here is what Barry Loudermilk had to say. He was on with, I think it's Brianna Morello over there at InfoWars. Shout out to Brianna. She was talking to him about this, and here's what he had to say.
You in regards to a letter that was recently sent out by you directly to Caroline Younger. She's an individual who was the first one who had discovered the first pipe bomb outside of the RNC back on January 6th of 2021. You're calling for a transcribed interview with her. What do you plan on trying to poke at and find out more information on?
Well, if you look at it, she is the only person who wasn't Capitol Police or FBI or Metropolitan Police or Secret Service that ever put their eye on the devices, right? She found the first device behind the RNC. It was right near her apartment. So she's the only civilian witness that we have to this. And she gave the FBI in her interview with them some pretty detailed description of it. And so I think she has some information that we can drive, because we still have this ongoing question that my committee is digging deeply into. We know via the videos that either Brian Cole or somebody associated with him that maybe had his phone place those devices. We have it on video that at least the one at the DNC was placed. And we know that they went over behind the RNC. So we assume that it was placed there as well at that time. However, the next day, the next morning, because Vice President-elect Kamala Harris was going to be at the DNC, the Secret Service came with bomb-sniffing dogs, and as they will tell you, and other law enforcement will tell you, they have the best in the world. Their dogs walked by the place, within feet of the place where we know on video the pipe bomb was put the night before and never hit on it after multiple passes. Mrs. Younger also claimed that when she found the pipe bomb at around 1 o'clock in the afternoon, there were 20 minutes left on the timer on it, and it was a 60-minute timer. She also claims that the device was not there earlier in the day on the 6th when she came out of her apartment. So putting those two things together, we need to know, were the devices put out on January 5th as we saw that they were, and were they picked back up on the 6th? And then placed back out again. These are some of the questions that we have, and I think she can shed a lot of light by, describing to us that, when she found it and when she went out earlier and it wasn't there. There's a lot of missing pieces that, I think that she can shed light on, especially now that there is a suspect in custody. I think it would be very important for us to compare what she says to what he says.
I couldn't agree more. So we're looking forward to more being revealed on this. And we have an update that the next detention hearing will be happening 12:30, just a few weeks from now. So we'll keep our eye on this. We'll see what else is dropping. This case is fresh out of the oven, and we're looking forward to unpacking it. So thank you for joining us as we do, my friends. Thank you for subscribing, and we'll see you back here on the next one. All right. It's been a beautiful stream, and my goodness, my friends, thank you for being here. Thank you for joining us, and thanks for bringing in all these new membos. My goodness, I don't even know what the total is, man, but we got a bunch of them coming in the house. And so let's see what you say about all of this and more. It is a beautiful day, and we had a great members only stream this morning. We were talking about that park pass, all sorts of fun lawsuits this morning. So membos, if you're just joining us, grab the stream from this morning. We had a good segment, a couple of good segments this morning. Michael Manson, hey, 33 months as a member. Merry Christmas to you and your family, Robert. Merry Christmas, Michael Manson. Thank you for being here 33 months, man. We've been through some serious stuff together. No doubt about it. Glenn, here's a hug to you. Tony Hay Muckets bringing in 10 membos. Look who's here. We got AC, 3 Jims. Michael Stetson, I think, is coming in. We got Retsy, bunch of gifts. Sam is coming in. Amazing to have Sam. We got Stalker Gal. My Alaskan Girl is coming in. Georgia Peaches, welcome. We got Squeaks in the house. We got Wendy. Shout out, man. So many good membos coming in, courtesy of Tony Hay Muckets. Rich Martin, Mig is in the house. Lori, welcome aboard. All coming in. Even more from Waffle Salter. Amazing Waffle Salter. What's up? Cindy's coming in. The old Desperado. We got Chris, Schlista, Steven, Marlon, J-Dog. What's up? We got another year older. Rich, Nicholas, Allison, Poppy Cats. Welcome. We got many others. Irish, Charles, Barry, Marcia, Vintage, Egress, Sean, Kyle, CM Red, Dominus, Thumper's here, Miss Kettle. Look at all these membos. Tony Hay Muckets is bringing in even more. The Ridge Rider, Gouveia. We got Ryan Hayes. Arctic Fox is here. Torque Wrench, welcome aboard. Tony Hay Muckets. Walter Salter also became a supporter. Man, great to see you, Walter Salter. Grab the members only. And you bought membos before you even became a member yourself. What a gentleman. Tony Hay Muckets, 5 more membos. 6 is here. Abel Baker, what's going on, Candy Ran? Nola, Sweet Blondie, welcome. Bernie, Neil, all gifted membos, courtesy of Tony Hay Muckets. Man, we got so many new membos. Great to have you, membo friends. Philip Butler, he showed no emotion. Sharpie Guy, great comments. Chubby, awesome to see you. And the defense was probably being nefarious for asking for closure, but I feel like the prosecution was just being lazy, which is just as bad. Yeah, just as bad. Laziness on this case? Come on. Jennifer O'Connell. What's up, Jennifer O'Connell? Says, miss my birthday, but Merry Christmas. Merry Christmas, Jennifer O'Connell. Well, 12 months is a birthday. Happy birthday to us, right? Happy 1 year anniversary. First year is the hardest. Gets easier from there. Hey, NC Native, thanks for putting in all the hard work to keep us informed on important legal matters, Rob. And thanks for doing it on Rumble. Native, thank you for watching on Rumble. Yeah, shout out to our Rumble friends in the house, including, and Neuro D's over there, mom the fort down for us. We got a nice crew over on Rumble watching over there. They hung the Lincoln conspirators. What's going on? Janek, Lil Galaxy, Dan Sundin. What's going on? Great to have you. Great to have you. We have some amazing Rumble friends watching us. E. Texley's here, says Kyle Seraphin has already spoken with Brian Cole Jr.'s mother and offered his services at no charge. Could this protective order be intended to shut out Seraphin? Kyle is convinced this guy is being railroaded. Yeah, that's interesting. Yeah, I mean, Kyle's been on this story for a long time. He's a former FBI official. And I don't think the order is really more, I would say, about erecting a fence around the information. So the lawyers and the people who are a party to the case can't share that outside. But if Kyle and the mom, for example, wanted to share information, like if she's got information, she's no, like, here's everything in his bedroom. Here's what I've got. You know, here are the text messages he sent to me. Here's, mom says, here's my alibi on J5 and J6. We were in the Poconos or whatever, you know, whatever. I think she could share that with him, and she probably has a lot of information. So I don't think I saw anything or heard anything in the order that would prevent that. But official case files shouldn't be shared from, like, the defense attorney to the mom to Kyle, is how I would interpret that order. So the lawyers wouldn't disclose that to mom. Now, they could see it, I'm sure, and maybe discuss it. That would be a different conversation. What if mom saw it? Could she talk about what was in it? But yeah, I think there's still a treasure trove. Like, Kyle is not limited by the order. Tony Hay Muckets. What's up, Tony Hay? Look at these new membos. U.S. Infantry L. Marhan is here. Mick Drummer. We got Tess Stickle is here. What's up, Tess Tickle? We've got Drew the Dogman. All gifted membos in the house. And we're very, very grateful to have you joining us. Thank you for being here, my friends. But, all right, we got some comments on locals, and then we'll wrap it up and call it a day. Dan over here says, Indiana Senate rejects the new House map defying Trump. Man, there's been a lot of that going on. John Thune was out there defying Trump today, too. Lots of that going on. And I'm not sure what the White House is going to do about that, but yep, a lot of it going on. Sadie, this meter could have a double purpose. It's called a TDS meter. Yeah, I wish that this would work for liberals. You could just kind of like hold this on their forehead, like apply directly to the forehead. TDS, total dissolved solids meter, generally. See how dirty your water is? I used to check this when I was a pool boy. Sometimes people would have like pool water that was like 20 years old, like this, like literally the same swimming pool. They never changed the water. It would change with evaporation and refilling, you get it. But once that happens, the solids stay dissolved in there. So you get a real high TDS on old swimming pool water, and that can make it difficult to maintain the water. So you have to drain the pool and refill it to get rid of the solids, because the evaporation leaves the solids behind as the water evaporates. But TDS, as in our context, is Trump derangement syndrome, and they were suing the National Parks case for that because Trump's face is on the park pass. The Veil says, just help the family find resources for their son, who is a veteran found on the streets, doped out, dealing with PTSD. Need to ask for prayers for him and his family during his recovery process. Looks like this is a long journey for them. Just got all the contacts and resources for them and been in the process of sending information to them. The Veil, you're a good person, man. Shout out to our veterans. Thanks for helping them out. And Amy Ann says, I'm watching Court TV, and Tyler Robinson's case is being covered pretty extensively. What do we, chop liver over here? I guess. All right. Hopefully it was a good show, Amy Ann. Thanks for being a membo and for letting us know it's a good over there. All right, my friends, it's been a beautiful and an amazing stream. Spuds gifted a membo over on Rumble, and Pinochet's helicopter tours got gifted a membo. What an amazing thing. Hyphen. Also, Pinochet, amazing to have you. Spuds, amazing to have you. Thank you for sending those in. Let's say hello to our friends on X, and then we'll wrap it up on the evening, my friends. It's going to be a beautiful day and a beautiful night. No doubt about it. Let's see what is cooking Over here, we have some comments. We do. We have a couple of X comments. What a nice thing. Neuro D. Hey, what's up? Make sure you follow Rob over on Rumble, baby. We have a great live chat over there. Truer words have never been spoken. Thank you, Neuro D. Meanwhile, Batorn says, judge in Oregon blocks the arrests of protesters for noise. I saw that headline. Says Massey isn't all bad. He wants to end NATO. Yeah, I saw that filing from him. And that was a good one. I'm not sure what this one is. Yeah, Kilmar was released from detention. He's free. Kilmar, wife beater Abrego. We're waiting for the DOJ to respond to that and figure out what their next strategy is. But I know. Vince, Candace is going to be responsible for tainting the jury. I don't think so, says Vince. I don't think you can blame her for that. You just ask people, did you listen to Candace Owens? No, I didn't. Okay, you're void-deered out. You're gone. Did you listen to Candace? Are you anybody here? That's the first question you ask the jury panel. Anybody a big fan of Candace Owens? Half the panel raises their hands. She's got like almost 200,000 people watching her, I think, right now. Yeah, almost 200. It's wild. So anybody listen to Candace Owens? Hands go up. You're struck for cause. All of you. You're all struck for cause. I'm sure there's people in Utah who have not listened to Candace Owens. So there'll be a fair trial in despite whatever she says or what anybody says. That's why we have voir dire. That's why we have jury selection. Tony, hey, it's the Munkets. I can't believe after all these years, you don't even remember that it kind of hurts. You don't even remember that it kind of hurts. I still love you, though. You don't even remember that. Hey, it's the Munkets. I mean, I haven't said it from Tony, hey, Munkets? Oh, well, I apologize. I'll do better at that. We appreciate all the membos. I do remember it, but I'm sorry it hurts. I don't want to hurt you, Tony, hey. Not even a little bit. So, all right, my friends, it has been a beautiful stream. Thank you for joining us, and thank you for being here on this lovely Thursday. We're coming back tomorrow. It's going to be Friday. Can't wait to see what is happening when we are back here. Struck for cause means that we have a good reason to not allow you on the jury because you might be a little bit too biased. So, all right, so we'll pause here. Membos, thank you for joining us. And everybody, thank you for joining us. Membos, grab the morning stream from this morning. It was a good one. We talked about some other fun lawsuits that were out there. And my friends, thank you for being here. Thanks for subscribing to our channel. If you haven't already done that, we'll come back tomorrow. We'll get into it again. But until we do, my friends, I want to thank you once again for being here. I hope that tonight you have a beautiful rest, you sleep very well, and you join us when we come back tomorrow. We have amazing mods and meme smiths who mod the fort down for us and keep things nice and orderly around here. Big thank yous go out to Muffin Rando. We got Donut Mind Me, John in the house, K Bean, Carrie B, Neuro D, Janek, Dog Digger, G-Gum, Elliot, and Just Rhonda, all modding the fort down for us, keeping things nice and orderly, making it a nice, beautiful festivity that we partake in. And my friends, thanks for being here. Thanks for liking the video on the way out. We're coming back tomorrow to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very, very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers shine in the light. Watching the watchers defending what's right. Watching the watchers stay each night together and live